Do you want a green card through employment? Great. Just don't mess up your PERM application, because trust me, one small mistake and you're back to square one. Now, it might sound simple, but it's not always that simple. Let's talk about some of the biggest mistakes I've seen in PERM, employment-based immigration applications, since I began practicing law in 2007. Mistake number 1, employers, listen up. The job description must match the actual role. If it's too vague or too restrictive, then you're going to be in trouble. For example, if your ad says that the employee has to have 10 years of experience in AI, but AI's only existed for 8 years, that's going to be a problem. Here's a tip. Work with an immigration attorney to make sure that the job's duties are realistic and that it fits within immigration's requirements. I've seen immigration deny many of these cases because of this thing. Mistake number 2 is because you're messing up the recruitment steps. The PERM process requires very specific recruitment options under the law. For example, you have to place newspaper ads, print ads, sometimes even radio ads. If your company misses a step, or post the job postings on the wrong date and in the wrong medium, your case is done. You have to follow the law and the Department of Labor guidelines to the letter. There's no shortcuts in this process. Mistake number 3, not offering the actual required wage. The Department of Labor has a prevailing wage requirement. What this means is that we have to file for a prevailing wage determination with the Department of Labor, and they're going to come back and tell us what wage would be paid to a similarly situated American worker who's doing the same job duties with the same education and background in the same zip code. If you pay less than that, then your case will be denied. For example, if the Department of Labor determines that the proper wage for this job is $95,000, but you post an ad offering $90,000, that's going to be a problem. You always have to obtain a prevailing wage determination and double check the prevailing wage before filing the case. Mistake number 4, the employee is involved in the PERM recruitment process. The potential employee cannot be involved in the recruitment process. That means they can't be involved with HR, they can't review resumes, they should not even be aware of how and where the recruitment is occurring. If immigration finds out that the foreign worker had anything to do with the recruitment process, it puts the case at risk. So here's my tip. Employers must, by law, handle this process exclusively without the employee involved to make sure that the case is legit. I know it's hard to find good employees and good help right now, but if you want to hire this foreign-born employee, you must follow the law exactly. I'm going to give you an example of a recent case I saw in which the PERM green card process was followed, but the case was ultimately denied. The Department of Labor determined that the prevailing wage was, let's say, $70,000, but it turned out that the employer's tax return showed that he only had $35,000 available to pay the employee. He wasn't able to pay the wage that was required, the prevailing wage, so immigration denied the case. In another case, the employer and the employee presented to immigration that the employee was working for the employer while she was on her OPT after she finished her master's degree. However, when immigration showed up for a site visit, she was not working there. And yes, immigration does make site visits. So unfortunately, this case was also denied. There are a lot of things that can go wrong in the PERM employment-based process. It's really important that you follow the law verbatim. That's why it's so important that you hire an experienced immigration attorney to help you. If you have any questions about the PERM employment-based green card process, drop your comment below or give us a call. I would be happy to discuss with you. I'm Jennifer Bennett. I'm an immigration attorney, and I help immigrants and employers hiring immigrants one visa at a time.